You're listening to the Immigration Lawyers Toolbox podcast, the podcast that keeps your practice sharp and your clients happy. I'm your host, immigration lawyer John Khosravi, and every week we're bringing you insights, tips, and real-world conversations with top immigration attorneys and industry leaders. Whether you're here to grow your practice, stay on top of the latest trends, or get inspired, you're in the right place. Ready? Let's go. Hello, fellow Toolboxers. Welcome to episode number 435 of the Immigration Lawyers Toolbox podcast, doing a regular monthly interview with our colleague, Gregg, a leader in the immigration space, knowing the ins and outs of the complicated court system, crimmigration, and traveling across the country and fighting the good fight. So it's good to have him as a friend and a colleague, having him coming here to share his knowledge. So it's always a popular episode. So thank you for coming. I also want to thank the sponsor for this podcast, Immigration by Serenade, who's also sponsored the magazine, the Immigration Lawyers Toolbox magazine, which I recommend you check out and, give articles, get yourself published at. If you want to catch the magazine, go to immigrationlawyerstoolbox.com and click on the magazine link. You'll find the information there to read all the back issues, and the content is really good. I could really vouch for that. I also want to thank them for hosting us webinars coming up on December 4th, Wednesday, December 4th at 10 a.m. Pacific, 1 p.m. Eastern. The webinar is called Keys to Building Resilience in Immigration Law for 2026. Great, pioneers in the space, Raquel Gomez, the CEO of Staffy, and our Vice President of Client Success, Anna Paris, are going to be, it's Anana Paris, going to be there speaking. And Trinity Burton, the head of marketing at Immigration by Serenade, is going to be there. So definitely save your spot. I'll have a link to registering in the show notes below. So you're going to enjoy that. And importantly for me, we're going to have our course, and for you, we have our consular processing course. Learn how to do consular processing live coming up December 18th at 10 a.m. Pacific time. Is it the same time? No, it's later. Okay. And we're going to go over DS260s, MVC stuff, packet, how the contract looks, everything you need to know other than the AFA support. That's a whole 2-hour session separately. Got to do on that. But really get started doing consular processing for your family-based cases, employment-based cases. I know how to deal with the embassy issues. A lot of attorneys, in my own internal survey of their practice, I would say a majority, like 70% of immigration lawyers, have not done consular processing. So it's an area that needs a lot of practitioners to get into, especially as it's going to be growing with the issues that exist. More people are going to be avoiding doing adjustment of status. For example, people who might be on tourist visas who would typically adjust status based on marriage U.S. citizen might be risky with the NTA situation that the government is going for and how wild life has gone. Might be better just stay outside and do consular processing. Whole bunch of new cases are coming there. You should know it. It is a premium course. There's fees for it. We'll put a link to register, and information will be there. But I definitely recommend doing it, joining live, and we'll have a good session. We can ask questions from you as well as we're going through it. If you just want to email me as well as questions, info@immigrationlawyerstoolbox.com. So email info@immigrationlawyerstoolbox.com. Having said that, none of the information provided here is intended as individual legal guidance. Please consult with an attorney about your case, which y'all know that already. Let's get the show started. Hi, Kevin. Thanks again for coming on the show.
It is my pleasure, John. I enjoy very much coming on your show and talking about my usually 3 cases every month.
It's a little bit easier than your own podcast, I imagine.
It's good. I prepare for it a couple minutes before the show, going through my outlines, and it's like a good review of the last month. I'm like, oh, yeah, I remember that case. It gives me an ability to skim them again. So it's like all this stuff, which was the point of my show too. And it's also part of the point of yours. Like, it all makes us better attorneys. Like, all this constant reading of the cases and reading of my summaries and remembering them, for me at least, and talking about them, it makes me a much better attorney, the actual doing.
They say if you learn something, if you teach it to someone else, then it's really going to stay. And that's that reiteration, the writing, reiteration, talking about teaching, where it just gets locked into the long-term memory.
That's a good point. I guess that's what my show is, teaching into the void. There's no interaction. Like, he interacts with me during it.
Yeah, the conferences. Are you going to come to the Long Beach? I can't remember. We talked about last month.
I can't. I have to. I'm already going to be in New York for something else, which is too bad because I love the California.
Yes, the first California conference I'm doing. My friend Nicholas, who's one of the chapter chairs, got me on, and I'm like, okay, Nicholas is going to be there. I'll come there too. So I'll be at the first day, the very beginning, the first one of it. But if anyone's going to be there, come check it out. But which conferences do you have coming up? Anything else?
Well, Nicholas is always going to be there. Nicholas, he's at every AILA conference in the world. Great guy. Conferences, huh? I've said no to a couple this year, mostly because of all the work and because of the 14-month-old. So I don't think I have any conference seasons about done. So I don't have anything booked. I've turned down some things, but I'm sure there'll be stuff more in the future, hopefully Ayla National, which is in San Diego. So I'll be there regardless, but that's next summer.
Definitely want to go, but then someone's getting married in Europe. And at first I'm like, no, but then I'm like, it might be a once in a lifetime opportunity to go to Switzerland.
Yeah,
But listen,
San Diego's nice.
it's easy to come to San
We
Diego. I
should
can
do.
just drive over there. So I don't have to get a plane in the same time zone. But one thing I want to do, I want to go to the Rome chapter meetings where it's like in Frankfurt or Netherlands and stuff. Even they changed the name for it. The Bangkok district is like APEC or something like that now. As soon as the kids get older, I'll go with them and do the conference and spend a week there and have some fun.
That sounds
All
cool.
right. So what do you have in store for us today?
Got good stuff. First is United States v. Rivera-Valdes out of the Ninth Circuit. Bonk Ninth Circuit, which uber precedent. It was actually published September 18th, but I just kept getting so backlogged, and it's not my core coming from removal proceedings that I didn't get around to it until last month on one of the October episodes. So it counts as an October case. And this is a big deal in the Ninth Circuit and elsewhere. Even though it's happening in the illegal reentry context, 1326 prosecution, it's about you can collaterally attack a 1326 illegal reentry prosecution. You can attack that by collaterally attacking the underlying removal order that supports it. So it really is about the legality of the removal order at issue. So it's very relevant to removal proceedings because this removal proceeding, or in this case, deportation proceeding, because it was before 1997, violated his due process, Mr. Rivera-Valdes. The reason why is exceptionally important to immigration. He was ordered removed in absentia because he didn't show up to his hearing. He was ordered deported in the early to mid 1990s. That was with the issuance of an order to show cause before they were changed to notices to appear. But I do believe that this holding should apply to notices to appear as well. Although orders to show cause, I want to say, had to be sent by registered mail or something. But other than that, this should apply. Former INS, before they became ICE, they messed up. He gave them his correct address when he entered, but they forgot to use the word avenue in what they gave him. And so the mailings bounced back. The notice of hearing didn't have the date, time, and place of his first hearing. And that just goes to show that's why initiating documents are supposed to have the first hearing. So they know right then and there when they have to appear. But in any event, it didn't have that. So then the court sends the notice of hearing. That bounces back. They've got the wrong address. They didn't include avenue. And they actually try to send him the order to show cause again as well. That bounces back. So he doesn't appear, gets ordered deported, gets physically deported because of that, and then comes back in unlawfully, gets prosecuted. And the en banc full Ninth Circuit had some very interesting things to say about why that conviction cannot stand. I think they have to dismiss this indictment. Quote, when the government learns that its notice efforts have not succeeded, that knowledge triggers an obligation on the government's part to take additional reasonable steps to effect notice if it is practicable to do, end quote. That's a huge deal for in absentia cases. All these cases, the FOIA will show all the time that actually notice bounced back. It was not actually received by the non-citizen. Now, there's a lot of case law that says you can't evade the mail, right? And you can't just move without informing the government. But even that is butting up against this rule from the Ninth Circuit en banc court, where it's saying that it is a due process violation for the government not to try to do something else when it learns that notice wasn't received. If there's not evidence in the record that the government did something else once the notice of hearing came back, it seems to me the Ninth Circuit is saying there might be a due process violation. Quote, process which is a mere gesture is not due process. The Ninth Circuit en banc even suggests things that the government could do. They could go back into the A file and make sure that there's no other address in the A file from the past to send notice to. That seems like something you could make a case out of through a FOIA. Any other address and the government didn't then try to send it? Due process violation. Reopening your in absentia removal order. Another alternative for the maybe sending the notice of hearing by first class mail. Government didn't do that in your in absentia case? Reopening. Motion, at least, due process violation. And the Ninth Circuit is very clear that its examples are just that, examples. You can come up with lots of practicable things that the government can do when the record shows that notice wasn't received as the basis for your in absentia motion to reopen in The Ninth Circuit, United States v. Rivera-Valdes. I haven't heard of anyone trying it yet. It's a relatively new case, but best you believe, that's an important one.
I don't know the facts of the case. We'll get into the record here, but what would they do? Because they said they're going to reopen the case now in removal proceedings for an essential work that was improper. But then it's like, what is going to have an asylum case, or is that's going to have a headache?
That's true. Sometimes that's a problem for future you, especially when you're rotting in immigration prison. If you just want to get out, maybe you could get a 601A waiver. Maybe you have a lawful admission and you're adjustment eligible now. Maybe you have a cancellation case because the notice to appear was deficient, didn't have the date or time or location, and so the stop time rule never stopped, and you've married a U.S. citizen and you've got a cancellation case. Maybe now you're eligible for voluntary departure. Yeah, maybe you have an asylum case. There's other possibilities, but that's a problem for future you. I don't think it's necessary to show that reopening is required under this case with the right facts. It's always helpful, of course, to show that once it's reopened, there'll be some sort of claim.
I imagine that you probably have some benefit as possible to go through the costs and to appeal it all the way to inbox. Like, do you know who the lawyers were? The immigration lawyers or other types of lawyers?
No, it's United States v. Valdez. It's the federal public defenders, in this case, out of Portland. Like, federal public defenders are often making good law in the 1326 context and in the categorical approach context, and they're very smart, and they're taking it all up because it applies to their criminal clients, and they're paid for by a variety of means their clients don't pay.
Federal public defender. It's not the federal government's not paid for it. Just call them the federal public defenders. That's the name of the organization.
Yeah, it's weird. I don't think so. It's weird because they're also subject to the shutdown in part. I feel like money comes from the federal government, but also other sources. It's this weird relationship. And I think every local federal public defender office is a bit different, but they're a constitutional right. Like, you have a constitutional right to an attorney in criminal court. And if you can't afford one, you get a federal public defender. So they're part of the system.
Yeah. Yeah, the U.S. courts has.
I don't know. Your tax dollars at work making good immigration.
Yeah, that's cool. All right, what else do we have?
By the way, I've also come to learn that the federal public defenders are getting assigned to habeas cases, at least in San Diego. So that's a big deal too.
And that's like the big
Maurice
topic.
Bondi.
Are you guys booming with habeas cases right now?
Oh yeah, we got a lot of habeas cases. We're getting some wins and we're getting some good settlements too, but also some actual wins from the district court judges. I wish we weren't in this world, but we do find ourselves in this world, and we are prepared to fight, and we are.
So when someone gets detained, they might be like even deport quickly. You got to jump in and make a filing, or like it has to be quick. What was a typical habeas client?
Habeas is there was actually a recent 10th Circuit case about you can get attorney's fees in habeas. I'll actually be talking about it in this week's episode of the podcast. Habeas is older than the U.S. government. It just means someone's liberty. Really, to paraphrase, someone's liberty, or even the U.S. government is trying to do something, and you're saying you can't do this, and here's why. It's usually liberty and freedom from custody. The reason for habeas immigration is varied. Maybe it's a Zadovitist type unlawful prolonged detention. Maybe it's challenging matter of hurtado, that the BIA's new interpretation of all IWIs being subject to mandatory is wrong. Not even giving them a bond hearing is illegal. Winning a habeas doesn't always necessarily mean an order that they're released. Sometimes it means an order that an immigration judge has to give a bond hearing. Of course, you try to draft it to also get the immediate release. A lot of habeases that I think are successful, and this is quite the pet peeve of mine too, is against ICE's regulatory to literally challenge to, if a bond is granted, to file within 24 hours a notice saying we're going to appeal and you need to keep him detained while we appeal. There's a regulation that in a lot of circumstances allows ICE to do that, which is just so wrong to me. And lots of federal judges have said, yeah, that's wrong. Like, DOJ, DHS created a regulation. That's cute. The statute, it's ultra virus. The statute says nothing about ICE having this like veto over a bond during an appeal. So those are just some examples of when a habeas. Third country removal. Is ICE, their detention of people with withholding of removal, is it lawful in compliance with the regulatory framework? And are they doing it appropriately for third country removal? Is that even lawful? And if it is, do they need to have actual plans? Can they just detain and then make them sit there for 2 months while they figure out how they're going to get them to Ghana, even though they're from El Salvador? All of these things. And so your main question was, you file ASAP because that can prevent their transfer out of the district. And also it begins the clock whereby the federal court actually is the one that orders the government to respond by a certain amount of days, which is a weird thing for federal court. It's usually you serve the government and then that starts a 60-day clock. It's much more expedited in habeas, and it's the federal judge that's in charge. But also, if things are really expedited, like you think your guy is going to be sent off soon, you have to file a temporary restraining order, a TRO. And then, you have to certify it's an emergency and you're in federal court in the
Wow.
day. So things get pretty serious very
Nah,
quick.
that's like hardcore lawyer. It's like TV show lawyer. Yeah. Can't go to court.
It's wild. And we've expanded our firm a bit to accompany it. We've got a new attorney at the firm, for example, Yosef. He did 16 years at
Mhm.
oil.
I saw you.
He's been doing
I
habeas.
saw you posting on LinkedIn right now.
I, of course, do habeas. Yanal's doing a lot of habeas. Ed Ramos has been doing so much of our habeas for so long in federal court litigation. And then, of course, there's Ira John, Helena. And really, we all dip our toes in.
I saw you posting on LinkedIn that you guys are hiring two practitioner, 2 to 4 years experience.
We are in Miami, though. Last time I did this, I got a lot of remote, no remote. We need a body in Miami. Even though I'm a San Diego guy, we're still a Miami-based firm, and we need Miami
Yeah.
bodies. It's Miami because South Florida's on fire. The whole world's on
I
fire.
just applied. I copy pasted that post on the job listing page on our circle.so community page. So we have a lot of job postings. I copy pasted for anyone looking for a position.
Appreciate you, John. Thank you.
Cool. So what do you have next for us?
Hey, everybody, I want to jump in really quick to remind you of our consular processing live program December 18th at 10 a.m. Pacific time. I'm teaching it myself. Come join. We'll have a private group. I'm going to go through A to Z of the situation for consular processing so you can add that to your practice or master it and learn the nuances we deal with. Consular processing, just how it went, is one of the first kind of cases I did. I've always been doing it. So to me, it's like second nature. But as I've talked with so many immigration lawyers, I saw that a lot of them don't do that. They might do court work, asylum work, even employment-based work. A lot of employment-based lawyers, they do H-1B and EB-2, EB-3, all this kind of stuff. They never deal with the embassy. And so it's very important to know in the nuances that deal with embassies, especially as the craziness is happening where people can't do adjustment or they're coming from countries, China, India, Russia, Iran, where there's always going to be some administrative processing or glitches that happen. So you got to be careful for. We're going to get into all that. Email me at info@immigrationlawyers.com, toolbox.com to get more information. We'll have a registration link in the show notes so you get that as well. Definitely join and really take your practice to the next level. Let's get back to the show.
Maurice v. Bondi out of the First Circuit. And I think I talked about the Rosa case on your show a couple months ago, which also for the first. And this case is a continuation of that. But I'm not going to stop beating this drum because it's just so important. This guy, and I don't know, maybe he's a bad guy, maybe not. He's got quite a few domestic violence arrests and some charges and a really bad police report, but no convictions, and the charges were dropped. And maybe there were some pending ones during this, but I don't think so. This case is in the context of adjustment of status, discretionary relief, an immigration judge denying based on what was said in the police report. And the First Circuit is again saying you can't do that. Quote, a police report, absent a conviction, must be corroborated before the agency may give the report substantial weight in denying adjustment of status as a matter of
Nice.
discretion. End quote. So if your guy comes in and is denying what's in the
Yeah.
police report and they don't have anything else, like they can't really rely on it. And by the way, that's coming from the BIA's 90s decision in matter of Arreguin. So really that should be a nationwide rule, even though the current BIA has amnesia about old decisions as if they don't exist. But First Circuit really beating this
You
drum
never know what kind of crazy
on
stuff will be in there.
discretionary adjustment of status.
You never know. Yes. Is USCIS a court adjustment or is it applied to USCIS as well?
Yeah, technically this applies to USCIS in the First Circuit too, but good
Yeah.
luck there. They don't act like they're a court or lawyers because they're not. But still, this should bind in the First Circuit and would be a absolute reason to appeal to the AO if that in the First
Yeah.
Circuit for sure. And it should be nationwide. Again, matter of Arreguin. The BIA that the First Circuit is in part
Yeah,
relying on.
I've seen some police reports where just cockamamie, wild things that are in there, like you can hit their inconsistencies, and it's, oh man, this is going to be some nonsense if they actually there's.
But you don't even need that. The First Circuit's saying if it's not corroborated and you deny it, it's not worth much. And that's a big
Wonderful.
deal.
Well, that's some good news for honest lawyering on the government's part, honest adjudications.
Yeah. I mean, and it's, by the way, that's the case in all law.
It's like hearsay or something.
Think the circuits. We thank the circuits for these scraps, and people are like, oh my God, that's great. It's literally the law in everything. Of course, you can't rely on hearsay documents without corroboration or without testimony in criminal law, in civil law. By the way, two people arguing about $20,000, like you can't get this
Yeah.
in. And isn't removal and a green card a little more important than 20 grand? I think there needs to be a whole reset. And that's about marketing and reminding America that immigration matters and that these people have rights. But that's a bigger conversation.
Thanks so much.
That's
That's
only
only two.
two.
Okay.
We had a side discussion about
Okay,
habeas.
okay. So yeah, what do we got next? We have time. I'm not rich today.
Amos, the Attorney General out of the Third Circuit. This one on October 1st. This one is just so much, and I'm not going to get into everything. It's just there's so much going on in this case. What I find it most interesting for is the discussion of particularly serious crime and Convention Against Torture Protection. There is a budding circuit split happening about the matter of NAM analysis required when you're going to deny asylum and withholding of removal, especially when you don't have an aggravated felony. Or if you do and you don't have an automatic 5-year imprisonment, is it a particularly serious crime for withholding of removal, for example? And it's a 3-step analysis. And the first step is the conviction of the type and nature that would make it particularly serious. The majority of circuits, and now the Third Circuit agreeing, are saying that's like the categorical approach. You can't look at the facts of the conviction, step 2, step 3 of the matter of NAM analysis, if the conviction itself, if the statute isn't of the type that's making it particularly serious. What is of the type that's particularly serious? It's usually violent stuff. After that, it gets mushy. This was conspiracy. Was it conspiracy to, I think, to commit immigration fraud, something like that. And the Third Circuit is saying, let's Section 371 federal conspiracy to commit a 1542 offense. Some conspiracies are more serious than others. The Third Circuit talks about a conspiracy to steal a book of stamps as not being that serious. And then the Third Circuit is saying you need to go to the underlying elements of the underlying offense. But this is what's really important to me. Quote, a conviction for a conspiracy to commit a substantive offense does not require proof of all of the elements of the substantive offense. It does not even require proof that the defendant committed any overt act in furtherance of the offense. End quote. Restated, the Third Circuit is saying to get a conspiracy conviction, you don't have to show that bad of things happened. So I don't know. That quote to me supports the argument that a conspiracy statute is never a particularly serious crime, at least federal conspiracy. It's interesting. I think the Fourth Circuit would beg to differ if I'm remembering correctly, but pin this in the ever developing areas of conspiracy, criminal, and particularly serious crime stuff. And I know that I'm getting real into the weeds. And then there is some Convention Against Torture stuff in where the Third Circuit is saying, look, BIA, you can't just deny based on your belief that their predictions of what's going to happen to him in the future is speculative. Or because he didn't know his idea. That's the nature of, it's all about what's going to happen in the future. The future is always speculative by definition. What are you doing? And so there's a lot of recent BIA decisions that would indicate otherwise. So good on the Third Circuit. And also even the Third saying you don't even have to know the identity of the perpetrators to get cat protection. They could be wearing masks, explains the Third Circuit when they attack you, for example.
If you just pick a subject like this conspiracy and do a lot of blogs, articles, videos on it, you become an expert witness on it, and just keep up on that period of law. So all these other immigration lawyers, they'll find your stuff and just like, give it to that person or just hire an expert witness or something. So many niche.
Conspiracy is so complicated, and there's a aggravated felony which makes an aggravated felony any conspiracy or attempt to commit any other aggravated felony. So it's like layer of complexity on complexity, and then you bring in particularly serious crime. That's like a whole thing. Every time we get a conspiracy case, I'm like, all right, let me just sit down and look at this for 5 hours. Let me sit down and look at this for 30 minutes, and then I'll start.
That's why we have you here. You do the hard work and just fill me in on what's going on.
And I like
cases, federal wise will pop up. And I'm like, I got to write this down. I asked Greg, Kevin and Greg about it and like lose track. But
I'd welcome that conversation.
I keep it track because I was like, oh, he's probably going to talk about this one. And then I forget which one it was. But sometimes it'll be like somewhat immigration, but other related. So it doesn't come up within this stuff. But I'll keep better track of it. There's been like 3 or 4 cases in the last couple of months that I'm like, oh, wow, this is like interesting. Got to ask you about it.
That's a dangerous assumption because even in the precedential circuit decisions, there are over 20 a month, sometimes over 40. You cannot
Yeah.
assume I will be talking about it on your show.
Not the hard way. But I'll make a note, and that way we'll have some sort of like a track of what's going on. I do a synopsis review of everything that comes out, but as soon as I see the word cat in there, next one. So a lot of times cat.
You do a synopsis review of every single precedential immigration decision, like what I'm doing.
That's Astia sends it where it's like every federal court case. I read all those. It's just a paragraph or so. I try to see if there's any USCIS related stuff or anything that really pops up. I stopped subscribing to Law 360. I was paying for it. It was like $60 when it's left. But I'll read the headings, so it'll come up. And so all these court cases, a lot of those are this court case. So I got to ask Kevin what happened.
A lot of people do. Law 360, in our firm, Ira's the only one with the account, and so he updates us. Well, the headlines, Law 360 misses a lot, and they don't always summarize it in their head.
No, they try to get you to pay for it.
Yeah, it's not them. I mean, how do you summarize a 50-page decision in one line?
I was saying Fifth Circuit said this. I'm like, oh, I got to wait for Justia to do it and like I lose track or something like that. But I have that Justia said this. So usually between 3 to 8 cases that come out every week. And I just go read what's there, see if anything pops up that affects me.
I got 2 to read now. The Fifth and the Fourth Circuit published today. Jeremy McKinney, former AILA president, got a win on the fourth. I haven't even looked at it yet, but I look forward to reading his win. That's been a fun part of the podcast. Like, I know the people personally who are on these cases probably 25% of the time or more. So that's always cool to see your friends.
That's one of the coolest parts, I think, about immigration law is just doing more cases. My clients would be in the news. The work I would do come up in the news. It's like the world comes really small the more successful you come at your career because you're literally touching like what's happening in your country and in the world. That's immigration allows you to do that. That's the coolest thing. I was seeing on TV. I'm like, oh, I'm working on that. Or there's one guy who was falsely convicted for murder and they tried to deport him. And he posted on Facebook, like a couple minutes ago, I saw, I'm going to be defending this guy. I'm like, oh, that's wonderful. That's going to do this. So it's like people are actually affecting things in life, or sometimes you're doing it yourself.
And Randall's great. It has been cool how quickly you meet these people if you're going to conferences and being involved in the immigration world. It's a cool thing.
Definitely. So I got to have him on the show. I plugged him right now.
Yeah, right. Sorry? It's good. He's another nerd. He's got his Crimmigration Facebook group. So he's reading all the criminal law type things. So he definitely is one to be able to talk case law as well.
I might do a roundtable one day, how to run I like thinking about how to practice immigration law and how you could manage all the studying and how to find clients. Maybe I'll host a roundtable with you guys and talk about how you could live your life and do this kind of work at the same time.
We've been on panels before, nerd out on crimmigration. He's good. He's smart.
Good stuff, Kevin. Thanks so much for coming on. To hear a full boatload of cases, Immigration Review Podcast, I found wherever podcasts can be found. And if you want to refer cases too, that's what I do. Email him at kgregg@kktplaw.com.
John's just the nicest, isn't he? John's the best. Thanks again for having me on your show. It was great to see you. Talk to you next month.
Bye-bye.
Bye, man.
If you like this episode, follow us on Instagram. Our handle is Immigration Lawyers Toolbox, where we post the latest statistics, tips, and more. And stay tuned for more from the Immigration Lawyers Toolbox podcast.